Thank you for taking up this issue. I'm a little bit out of my comfort zone when we're talking about defense law, but when I first read the article about this happening and being allowed to happen, and you should all have the American Bar Association recommendation from resolution of support for this, as well as actual cases that have happened throughout our country where this defense was brought up in times of defending perpetrators of sexual abuse and battery, as well as death resulting. This is a gay panic, but has been expanded to gay trans panic defense. And I want to thank Secretary Roberta de Meza for putting this information in front of you. Certainly, I'm open to any and all discussions as to how to make this law better, but on its face, it seems to be common sense as to not allow this type of defense to be put forth in a court of law to allow perpetrators to get away with assault and battery and also death resulting for sexual orientations.
Thank you, Representative Marshall. Are there any questions for the sponsor? Representative Corvese.
I'm not sure that the question necessarily, Representative Marshall, could be answered by yourself, but maybe some of the other individuals in the room who have legal experience, the chairman or Representative Knight or Representative Coughlin. I'm curious. First of all, I think the bill has certainly some merit, especially the second two paragraphs. First paragraph, I'm a little confused about. So it would say that an individual who discovers that another individual he or she is with has not, let's say that individual has not presented themselves in a way that the first individual understands, okay? We have on the books, I'm sure we have on the books, hate crimes. If an individual is gay, transgender, penalties for assault, let's say, are increased because we have hate crime statute on the books, I believe. So I guess my question is to those who have a legal mind is this: if the defendant cannot use the result of discovery of knowledge about the victim's perceived gender identity, etc., then would that defendant be excluded from any hate crime charges? Because if you can't use something as a defense, can you be charged with something that would relate to that? I'm not being too eloquent, but I know what I'm trying to say. Mr. Chairman?
I don't know that I have the answer to your question off the top of my head. Mr. DeLauro is going to testify. I think the vice chair just said she'd be willing to take a shot at that.
Representative Corvese, as the sponsor of hate crime law regarding trans individuals, I don't believe we have heightened penalties. We are simply recording instances of hate crime. So the charge would be murder, I guess.
Or assault,
but,
or what have you.
or assault with no heightening because of the statuses or perceived status of the victim.
Then I was under the mistaken impression that we had somewhere along the way passed a hate crime statute that increased the penalties if it was due to gender-based, identity-based, if the assault or the action was based on that. So I guess then the question is moot.
I believe so.
Okay.
Representative Knight, did you want to add something to that?
I think Representative Corvese is correct. I mean, we do have a hate crimes enhancement statute in the books because I just saw it within the last year. And I think to answer your question, let's say, as a hypothetical, somebody kills a cross-dresser, they could be charged if the evidence showed this with, I believe, some sort of hate animus towards a person who has a different gender expression, and they could at the same time, under our law today, utilize, quote, the gay panic defense in the defense of that crime. What the bill before us today would eliminate that defense from their repertoire. And
So the question would be,
Yeah.
if this law were passed, would that individual still be able to be charged with the hate crime?
I think so. Yes.
Yes, Representative Coughlin.
Thank you, Mr. Chairman. Rep. Marshall, tell me if I'm wrong. Feel free to correct me on this. It seems like the thrust of this law is to take animus out as a defense. In this case, it happens to be gender or the other term used for gender or sexual orientation. But I think the heart of it is we're talking about animus. Would you be willing to expand this bill to include not just gender or sex orientation, but ethnic background, racial background, age perhaps, in given situations?
I can't see why not. I mean, from first blush, it seems to be common sense that it shouldn't be utilized as a defense in any instance to allow an individual a reduced sentence based on, sexual battery, death resulting. That's really the key to this, is to educate jurors as well as juries that anti-bias jury instruction basically is really what it comes down to, is that they cannot have a bias when they're determining a case based on this defense.
So we could expand it to race, ethnic background,
Absolutely.
age, nationality, et cetera, without deprecating your statute at all.
Correct.
Thank you, Rep.
Representative Price.
Thank you, Chairman. Yeah, it's a tough one. So let me see if I got this straight. So if there's a person that's identifying themselves as a certain gender, presents themselves to another gender of the opposite sex, and they're okay with that, like they think they're in a heterosexual relationship, and come to find out that they're not, and they have like a real problem with that, like a mental problem with that, and they maybe have some aggressions to that, being deceived and now have engaged in like some sort of a relationship, like a homosexual relationship that they didn't want to be in, or one of these other alphabet relationships that they don't want to be in. The courts are going to say that their actions are not justified because have been mentally traumatized by being deceived and engaged into some sort of a relationship. Am I correct in that?
You're correct in that. At no time is assault and battery and/or death resulting justified regardless in a court of law. And if you read through...
So it's already in... Go ahead, sorry.
If you read through this American Bar Association, there's some analysis here in regards to the medical capacity of an individual, and utilizing that as a defense. In some of these paragraphs here, you'll see that they've taken that possibility out of the...
So why wouldn't they be? Why wouldn't that be a factor in the mental stability of someone that has been deceived and engaged in some sort of a sexual activity that they were not privy to, you know? Like all of a sudden, you think you're with a woman, and all of a sudden the woman has it's not a woman. I mean, that's disturbing. That's very disturbing to heterosexual men, and could be. I think that this bill is not a good bill.
Thank you.
Yes, Representative Vella Wilkinson.
Thank you very much, Mr. Chairman. Representative, thank you for this bill. Based on what my brother was saying, if a woman was deceived by a married man who she thought was available, she could use that as a defense to knock the hell right out of him, quite frankly. We already have laws in the state of Rhode Island that protect individuals based on their gender identity. And I think that this is the right step to go. So I'm in full support of what you're doing. Thank you for taking the courageous step, because I'm sure that there'll be a lot of people that are unhappy with us. But thank you for taking the next step. The state of Rhode Island has always been on the forefront of protecting individuals based on sexual orientation and sexual identity. Even when the federal government didn't do it, we were within the first 14 states to offer these protections. So once again, I'm in full support. Thank you for taking this action.
Thank you, Rep.
Thank you. Representative Almeida.
Thank you, Mr. Chairman. Rep. Coughlin took the wind right out of me. He was right on point and regarding race or ethnicity. But I'm reading the back here, the special committees and commissions. So the Center for Racial and Ethnic Diversity, the Educational Pipeline, I guess they must have given an opinion on this, or have you received anything from them regarding this bill at all?
I have not.
Have you received anything from the NAACP regarding this bill?
I have not, but I also have not. It was just introduced, and I would assume that they would be on board with it.
Oh, they will be told. Thank you. Appreciate it.
Thank you, Representative.
Yes, Representative Price.
Chairman, I guess my standard question is, where is this legislation stemming from? What's the precedent for this?
Well, if you look in what I presented to you as articles, as support, American Bar Association took this up in 2013.
Excuse me. What's the Rhode Island precedence? Is there something in Rhode Island that is doing this, or is this a national movement?
This is a proactive movement.
There's no. Go ahead.
Representative Price, let him ask a question, but let him answer it, please.
So where in Rhode Island? What are we addressing in Rhode Island?
It has not happened yet. And what the purpose of this bill is to be proactive, so it never happens in Rhode Island.
I will be able to speak on that matter. Sir, it's not the appropriate time.
So ultimately, if you read through this again, they're recommending that states take action and be proactive in regards to this bill. State of California and Illinois. State of California has passed the law. The governor signed into law, and the state of Illinois has also took up action and is moving forward passing this law, as well as other states in the country. And ultimately, I've always seen as Rhode Island being a proactive state and being ahead of a situation. I'd rather be proactive as opposed to being reactive, and having one of our friends or family or neighbors having to go through a situation where their loved one had somebody assault and potentially kill them, and ultimately get off on a lesser charge based on this defense.
I applaud your what you're doing here. I don't agree with it because it seems like we're trying to make a law for something that's not happening. Proactive. We could say it's proactive. I understand that, and Is there examples in different states where this has happened?
Yes.
And how many of it? I mean, how many examples are there?
So if you look in your second packet that I've submitted to you, it starts out with the United States of America. You'll go down.
Yep.
There's case after case that has happened in other states where this is actually taken, and defense has actually played a role in a reduced sentence for perpetrators.
Okay, so the judiciary, so the judges have reduced the sentences, so they have used their judicial power throughout the process. Is there? I don't understand what the problem with that is. If it's gone through the judicial process, we're trying to change that because we're not agreeing with our judges.
Regardless of sexual orientation, no individual, in my opinion, should be subjected to sexual assault and battery and death resulting without being convicted to the full extent of the law. This should not
But
be.
didn't these cases all go to the through the judiciary process? And
It did, and in these particular states,
so we're going against it.
this defense was allowed. What we're trying to do here is, in the state of Rhode Island, not allow this defense to be allowed. And you'll probably hear from some people that say that it's unconstitutional to say such a thing or do such a thing. But at the end of the day, with no disrespect to the judicial system, we have jurists that are both liberal, and we also have jurists that are both conservative. And they house religious ideologies and convictions. And in some instances, those will play a role in findings and ultimately serving of penalties.
With all due respect, it sounds like we're trying to overstep the judiciary process.
No, I think we're just trying to protect our electorate.
Isn't that why we have the judiciary process?
I believe so, but I believe that at the same time, a defense mechanism of this nature should not be allowed.
Thanks.
Okay, any further questions for the sponsor? Okay. Now, have you signed up to testify? Okay, all right. Well, then we'll get to you in a moment. Could we hear from Mike DeLauro from the Public Defender's Office?
Thank you, Mr. Chairman, members of the committee. So I think that Representative Price hit it right on the head when he said that this is a tough issue. I think that was the first thing that he said. It is a tough issue because I agree with Representative Marshall when he said that this is a vulnerable, I think what he's saying is that this is a vulnerable population that needs the protection of the law, and I agree with that. The problem that I have with this is the way our system of justice is set up, not just in the United States, but here in Rhode Island. So I think it's helpful to say and to understand that any trial, any litigation really, whether it's civil or criminal, is meant to be a search for the truth. And what that process requires and what it entails is that there be a wide open and robust examination of the facts of the case in the form of the evidence that is introduced. And it could be in a bench trial with just a judge, or it could be a jury trial. It doesn't really matter. The fact is that at the end of the day, that body, that entity, whether it's a judge or a jury, is supposed to determine and ascertain what the truth is. And what we do in this country is our judges assist juries in jury trials in that important role, and they do that by instructing the jury, giving the jury instructions on how a particular piece of evidence should be utilized and how it shouldn't. The best example is If my client is on trial for robbery and he were to testify and his prior robbery convictions could be admitted to impeach his testimony, the judge would tell the jury, you may not use this information to determine whether or not this defendant is guilty of the offense. You can only use it on the issue of whether or not this defendant is telling the truth. And that would be the case with any witness with a criminal record. The other thing that judges do is judges act as gatekeepers. And at the request of either party, whether it be the state or the defendant or plaintiff in a civil case, the judge can be asked at any point, ideally at the beginning of the trial, but really at any point, to not allow a particular piece of evidence to go before the jury because it's irrelevant. And that is a function that responsibility that we put upon our judges to do that. Our concern with this piece of legislation is that it inhibits potentially the introduction of evidence that could very well be relevant to the determination of the truth or not the truth in a particular case. And it does that by saying that, and the best example I could give you is the last part regarding self-defense. So in a criminal case, when you raise self-defense, the jury would have to find to excuse a defendant by engaging in self-defense. The jury would have to find that the fear on the part of the defendant was a reasonable one. And just thinking about it in my own mind, I'm thinking about how could someone's gender or sexual orientation or how they identify could be reasonable. I can't think of a singular scenario that it would be. Diminished capacity is a defense that is used in Rhode Island where it could be described as heat of passion or voluntary intoxication. It can only be used in cases where it's a specific intent crime, and we don't have a lot of specific intent crimes in Rhode Island. There's murder and a couple of others, but we don't have that. The provocation part, I'm not really sure what that refers to. I'm not really aware of a defense of provocation. I am aware of the other two, so I'm thinking that this legislation addresses a problem that doesn't exist in this state. I have to confess, I haven't heard of the defense of gay panic. I haven't read the material in the ABA that has been put out by the ABA. I probably should, seeing as I'm a member of the ABA. And I'm unaware of any such cases here in Rhode Island. I like to think, given my job, that I would have heard about it if one had been raised. So I think the way our current system is set up, we're prepared to address situations like this. Hopefully they won't occur, but if they do occur, our judges are experienced and knowledgeable in dealing with what evidence to let in front of the jury and the appropriate instructions to give the jury on how they might use that evidence. So with that, I'll try to answer any questions you might have.
Thank you, Mr. DeLauro. Any questions? Representative Price.
So thank you. So let me see if I'm getting it correct, what I'm understanding from you. So you think that the judges already have the ability to handle this situation as it stands now? And another thing is, I'm reflecting on that. There's no cases that have happened in Rhode Island that have fallen under this category. So we're trying to address a problem that doesn't exist in Rhode Island.
Taking your second question first, I'm not aware of any such case where this type of defense has been used. And yes, I do believe that our judges are equipped to handle sensitive case. This would be a very sensitive case. If someone were going to raise this It would be a very sensitive case that would have to be handled in a very sensitive way. And I would anticipate that someone, whether it's the prosecution or the defense, would ask the judge to rule on the admissibility and the relevancy of such evidence before the trial even began. And there's something that I think responds to your question, too, that I meant to say and I forgot to say before. All of these three defenses that, well, again, I'm not sure what that meant by provocation, but the other two, these defenses were not created by the General Assembly. They were created by the Rhode Island Supreme Court by case law, by what we call the common law. So when the jury is told at the end of a case about diminished capacity or about self-defense, really what the judge does is grabs the most recent or the best case on self-defense and reads it to the jury. Now, they may, ad-lib a little bit, but the bottom line is the Supreme Court tells us what the law is regarding self-defense and diminished capacity. Self-defense, there is one that deals with if somebody breaks into your house and you kill them. This body did enact a statute dealing with that, but the vast majority of the law in this area has been established by the courts. So I wonder how this body, attempting to change that, how it would work other than making a big mess where a problem doesn't exist.
Thank you.
Yes, Representative Almeida.
Thank you, Mr. Chairman. Mike, I'm trying my best to go over all the stuff that's here. Kudos to Representative Marshall for bringing this up. Are you saying that because this didn't happen in Rhode Island, we're not saying that this issue just hasn't been gone over or given an opinion by a judge at this point?
What I'm saying is that, I guess I'm saying two things. I'm aware of any case where this has been raised, where this type of defense has been raised, and the judge or the jury then had to deal with it, right? I'm unaware of any. I'd like to think, although it's just short of speculating, that if it were raised, that the law that's currently in place would allow our system to deal with this sensitive type material as it ought to be dealt with. I mean, we have an example years ago. We had, this body passed a rape shield law, and it gives instructions, I think, on how very sensitive evidence ought to be dealt with. And so we have things like that in place already.
So, a homicide and assault based on this quote-unquote gay panic attack, would a judge be able to, would he change the way in which he would make a decision, or the jury?
Well, the first thing you would have to do as a defense lawyer, you would have to say, the jury only gets instructed based on the evidence that's submitted to the jury. So if you have evidence of self-defense, who struck the first blow, who's bigger, who's smaller, who had a weapon, who didn't, all the facts of the case, you would have to have some facts to get the judge to give the jury a self-defense instruction. Otherwise, you don't get it. I dare say if the only evidence in the case were the sexual orientation of the victim, that, and again, every case is different, that you'd be hard-pressed, I think, to think of a scenario where the judge would give that self-defense instruction to the jury. In other words, it's not reasonable, right, to do something to someone because of their sexual orientation. Everybody agrees to that. The question would be, in that situation, would the defendant be entitled to an instruction on self-defense? I would say no. And same for diminished capacity. I think it's the same kind of thing.
And finally, I guess it's more of an opinion. So I'm looking at these special committees that I brought to Representative Marshall. the Commission on Racial and Ethnic Diversity, Racial Ethnic Justice, Sexual Orientation. It surely brings me down memory lane because civil rights has always been, not this exact quote, well, it's not happening here. Well, it is happening here. So when you and I, the ACLU, have gone through a lot of different bills where people would say, no, it's not happening here. We can go way back to housing. We can go back to the right to vote. We can even go back to, well, the correct term, I don't know, it's comprehensive. I'm calling it racial profiling, driving all black. But we always had to use numbers to make it happen. Would, in fact, something of this nature would be needed to prove a point based on mathematical figures or statistics of any kind, like racial profiling, let's say?
Well, that's a great question, and I haven't even really thought about that. I mean, obviously, if this were a persistent, daily problem that was happening, and I'm not saying, maybe it would be something that have to be addressed. At the end of the day, there's a basic assumption that goes into everything that we do as lawyers, as judges, as prosecutors, whoever, that in a jury trial, the jury is given the correct law that applies and makes the correct decision based upon what's given them. And I'm amazed, even after all this time, I'm amazed at how well our system works when everybody does what they're supposed to do. The defense lawyer, the prosecutor, the judge. When they do what they're supposed to do, they do the work, right? And I really believe that in a factual scenario envisioned by this bill, that it could be dealt with appropriately.
Mike, I thank you. Having a war in a uniform twice and having served twice with the gay community, I don't have a problem with this at all. So thank you.
Representative Filippi.
Thank you, Chairman. Hi, Mike. When the defense of self-defense, when it's asserted, we look at the circumstances surrounding the assertion that the person felt they were under imminent fear of reasonable bodily injury.
Right.
In the case of a woman who shoots a male attacker who was coming at her, in cases now, I think the woman would be able to argue that a man would be potentially much stronger than her. She's petite, and she felt in reasonable fear of imminent bodily injury because a much larger, stronger male was attacking her. Would we be removing the ability of a woman to use the attacker/victim's gender in her defense to explain why she had a reasonable fear of imminent bodily injury if we were to pass this bill?
Well, again, that's a difficult question. I would say that the thing that I'm confident in saying is that, when we think about the language of a particular piece of legislation and, we're crafting it and you say, okay, we've dealt with every conceivable situation that could come up. Believe me when I tell you that there'll be something that will come up that we can't that won't fit in the box. We had a training last week in my office on expungement, right? And we thought we dealt with everything when we dealt with expungement. Well, guess what? We didn't. Because, again, there's the facts of cases are very robust and they differ from case to case. It's a very long-winded way of telling you that, or saying that it's important to recognize that legislation like this could infringe upon the use of perfectly valid legal defenses in criminal cases. Yes.
Thank you. And one of the concerns I have, Mr. Chairman, is that this might inhibit the ability of a woman claiming self-defense against a male attacker. Thank you.
At the end of the day, too, just to answer your question, if I may, Mr. Chairman, when I talked about, everybody doing their job and doing their work, right? I've always been impressed at how seriously juries take the responsibility that's imposed on them. Back when I was trying cases, I used to try to talk to the jury after a verdict. You know, win, lose, or draw, you can always learn. You always learn something from them. And I'm not surprised anymore on how seriously they take their responsibility, at least in this state. You know, it's part of a process that it has to work a certain way, and everybody has a role to play. And I don't think this helps that.
Representative Price.
So I just want to, you know, preface my remarks with, you know, I don't have any problem with anybody's gender or whatever, you know, however they want to live their lives. But with this, the way this is written, would this condone people with other gender preferences to push their gender onto, you know, say heterosexuals and be eliminated from any ramifications from it? Because, I mean, I guess what I'm saying is, if someone presents themselves as a certain gender and it goes to a certain point, and then the other gender, heterosexual, you know, gets mentally freaking unstable about this thing, you know, like finding out that he's been kissing someone that he doesn't realize he's been kissing. What are you talking about? So, I mean, that's legitimate, isn't it?
Representative Price, do you have a question? If you have a question,
Yeah,
ask.
the question is if someone presents themselves as a gender and you're engaging in a relationship with them, and then you find out they're another gender and you're upset with it.
Yeah. Yeah, Representative Price. And why would you be asking Mr. DeLauro this question?
Because this bill eliminates that from the law, right?
Okay, do you want to ask the sponsor of the bill that question? Mr. DeLauro did not introduce this legislation. You understand that?
No, I'm asking him.
He's here on behalf of the Public Defender's Office trying to talk about the bill.
Right, and I'm asking him a question. I mean,
Okay, go ahead, ask your question.
Is this not an appropriate question?
Well, that's not for me to determine.
Okay.
Go ahead, ask your question. I'm trying to get you to the question. So far, it's just been a statement, so maybe you got cut off. What's your question?
Okay. If someone engages in a relationship and gets to a sexual encounter, and then they find out that the person that they've been in the relationship with is not the gender that they're been presented with, will this be admissible in court if they, you know, get a little upset about it? You know?
I'll answer the question for you. No, that would not be admissible.
Okay, so this is
it would not be available.
Is this condoning lying to people and presenting people as a different gender and misleading people into a relationship that mentally disturbs people when they find out what finally happens?
Representative Price, I don't think Mr. DeLauro is the right witness for that question.
I'm not pointing at this. I'm just
Okay, but this is during the committee process. We ask questions of witnesses. So I'm just not sure that he's the right witness for this question.
sorry about that, Mr. DeLauro.
Oh, it's all right,
Could you
you know.
answer that question? I mean, do you want to? If you don't want, that's fine.
To be honest with you, Representative Price, I'm not sure I understand your question, and I'd hate to just go out on a limb not fully understanding it. Does this, I mean, if you're saying...
Does it eliminate people from getting pissed off when they find out that the...
Representative Price, I'd ask you to use appropriate language for the legislative process, please.
Yeah, upset.
Will people still get upset if this is...
No. Will this eliminate if someone finds out that they've been deceived into a relationship and they get upset about it and might get a little physical about it, will that eliminate this from being presented in the courtroom?
I would have to say that it might, yes.
And
If that information is used as a defense or attempted to be used as a defense, this legislation would prevent that. By saying that the legislature does not believe that that is a permissible defense.
so,
And so we would be overriding common law, which happens all the time.
so one more question. So in your professional opinion, would you think that that's a good idea or condone that, or leave it up to the judge's discretion?
Well, I always think that the judge's discretion is the best way to deal with sensitive issues, and I think that any lawyer who chooses to be a litigator knows what they need to do to exclude some evidence from a case, such evidence from a case, or such a defense from a case. And you don't need legislation like this to do it, I guess is the simplest way that I could say it. And that's the reason I think that the law, at least in two of these areas, has been created by the court and not by this body, right? Because it is a matter of common law and because it's sensitive and deals with, you know, how people think about things. So I hope I answered your question.
Yeah, that was a long way around that question. Sorry about that, but thanks for your answer. Thank you. Thank you, Chairman.
Representative Vella Wilkinson.
Thank you very much, Mr. Chairman. Mr. DeLauro, thank you for your testimony this evening. I was wondering if you've had any opportunity to read through any of the cases that have appeared before the Rhode Island Commission for Human Rights with regards to complaints that were furthered by transgendered residents within the state of Rhode Island.
I have to confess that I haven't, even though I have an extraordinary amount of respect for Michael Evora, who I've known for a long time. That's the group you're talking about,
Yes, that's
right?
correct, sir.
Yeah, I'm a huge fan of his and of the work that they do, so shame on me that my answer to your question is no, I haven't looked at it.
Then with the chairman's indulgence, I would strongly suggest that you may want to have a conversation or take a look at some of those cases. The Commission for Human Rights has been providing, not as an advocate because that's outside of their mission, but they have enforced anti-discrimination laws that protect the transgendered community from a variety of discrimination, including employment discrimination. And I could tell you, sir, having been a former commissioner and as an administrative hearing officer, I can definitely see instances when things would get so out of hand in an employment environment that this population could be vulnerable outside of the four corners of their companies. So I would hope that you would keep an open mind, speak to Director Evora, and understand, again, as I had mentioned earlier, that Rhode Island has been in the forefront, and maybe it's not always sensible to wait until such time that an incident occurs. And when we had an opportunity to protect those who are vulnerable based on the fact that they want to live their true selves and engage in the sex re-identification surgery or however they decide to present themselves to the outside world. Again, this would not be unlike someone who was biracial and very light-skinned, who would be at the mercy of a brute who was a bigot and decided that because he or she was having sex with someone that was not purely white, they had the right to say, I was so enraged that I took matters into my own hands. So I would just ask you to keep an open mind with regards to this issue.
I'll absolutely do that, and
Thank you, sir.
I'll be seeing Mr. Evora
Thank you.
because we work together on things, and I will ask, I'm definitely going to ask him about that. Thank you for letting me know.
Yes, sir.
Okay, any further questions for Mr. DeLauro? Thank you, Michael.
All right.
Could we hear from, I'm going to call up, we have three witnesses signed up, so I'm going to call up all three of you. Mitchell, Campany, Sampson Hampton, and Randall Rose. Yes, this is something we do occasionally. That's why the 3 seats are there. If you're ready, you may begin. Just please identify yourself.
I'm Mitchell Campany. Did I do this right? Okay. So just go. So I'm in favor of this bill. I'd just like to say I agreed with a lot of what the previous speaker said in terms of it being a completely ridiculous thing to use somebody's gender identity or sexual orientation as a defense. But all you need is one judge to be unreasonable, and then you've got a problem, because I'm thinking, I'm not a lawyer, by the way. I work in software development. If I was on a jury, I'm pretty much going to take whatever the judge tells me is admissible as evidence as an admissible piece of evidence, because I don't have the background to know, oh, the judge is wrong about something this judge has spent his entire life studying. And then, so I might take that evidence as a juror and say, well, she was transgender, so it must be okay to kill her because the judge said so. The other issue you can run into, and I came prepared. I have a number of cases where this specifically happened where I would like to tell you about. I won't run through the whole list because it's already late. But the other thing you have is, as long as one juror out of 12 is what the previous speaker would call an unreasonable person, 1 out of 12 throws you to a hung jury, and then the prosecution's got to go, okay, do we do this again? And if they go again, then you're in that same situation where 1 out of 12 people can throw the whole thing into disarray. So, as you've already heard, this practice of using the gay and trans panic defense has been banned in California and Illinois. Those are the only states to do it so far. You've also heard the American Bar Association has suggested that other states follow suit, and that's what this bill would do. Those bills previously passed in 2014, and then again last year in August 2017. It's usually invoked in cases where the guilt of the defendant is unquestionable. We know that they did it, but it's used to strengthen the traditional defenses: insanity, diminished capacity, provocation, and self-defense. So you're going into a case, they know it's guilty, but what are these other scenarios? While using the gay panic defense to explain insanity has not been successful in winning a complete acquittal, diminished capacity, provocation, and self-defense have all been used successfully to reduce charges and sentences. Historically, in U.S. courts, use of the gay panic defense has not typically resulted in the acquittal of the defendant. Instead, the defendant was usually found guilty, but on lesser charges. And there are a few examples of those. The first one was in August 1954 in Florida, not particularly relevant to today, but the people who were convicted of manslaughter instead of first-degree murder. There is an example in 1965 where somebody beat an old man to death with a club and received second-degree murder instead of first. In 1968 in Illinois, they convicted the defendant of murder for that, but it was later reversed, determining basically on a technicality, saying the court has to allow somebody's sexual orientation to be used as a defense, because at the time homosexuality was or sodomy was a felony, so then you're killing a felon, and then that apparently had to be used. 1970 in Missouri, they charged the defendant with first-degree murder, and they later dropped it down to manslaughter. 1975 in Massachusetts, they did find the defendant guilty of first-degree murder, but the reason why is because the defendant was drinking alcohol at the time. The defense otherwise would have been fine, but because they were under the influence of substances, the defense was not allowed. 1981, Alaska, The murder was dropped to tampering with physical evidence and manslaughter. On appeal, they got rid of the conviction on manslaughter. Lincoln, Nebraska, 1986. And then, hold on, I have a note here. So 1987 in Utah, the claim was a defense against a homosexual advance, but was unable to present any evidence at trial to support this claim. So what the trial devolved into was not whether a murder occurred, but how do we prove whether the victim was gay or straight, which I feel like is a ridiculous conversation to get into in the middle of a court on murder. Who cares whether somebody's gay or not? That's not a justification for murder. 1988, there was a case where they went to, found the defendant guilty of theft, confinement resulting in serious bodily injury, and voluntary manslaughter. That defendant has since been released, so there are currently people alive, free in the world, who have used this defense to reduce their charges. I get rid of this one. 2008, in a case involving minors, the first trial resulted in a hung jury, so I brought up that hypothetical, but that has factually happened before. Ended up pleading guilty to some charges on the second trial. 2010, Mississippi, the defendant was charged with capital murder, ended up pleading guilty to manslaughter, arson, and burglary. Most recently, there have been successful uses of this defense in 2005 in California, which likely was the prompt for them to pass their law. I don't know for a fact. The first case resulted in a hung jury. Again, they went to another case where 2 of the 3 defendants were guilty of second-degree murder, hung jury on the third, and then they failed to return the hate crime additions because of the trans panic defense in this case. And the most recent case that I have found was someone was beaten to death in Harlem on August 17th, 2013. The killer was not indicted until March 2015, even though he turned himself in 3 days later and admitted that he did it because he went into a blind fury when he realized the victim was a transgender woman. This man was not charged with murder. He was also not charged with a hate crime. Later pled guilty to manslaughter. Ended up 12 years in prison, so will likely end up being let out recently. I don't have a case of this in Rhode Island, but a point I would like to make is just because something has not happened doesn't mean it will never happen. And a lot of what we need to talk about is, has this happened yet? Because I believe it will make its way to Rhode Island if it's happening in New York in 2015 successfully. Like New York, it happens in New York, which is also a pretty left-leaning state, pretty okay with transgender people overall, comparatively to other states in the country, I believe. But New York just has a lot more people than Rhode Island, and that's why it happens. It has a lot more people. There's a lot more people that are going to get murdered just as a function of math. And the reason why I think this bill is so important is because of the increased violence we see towards the LGBTQ community. I have some facts and figures about that from the National Coalition of Anti-Violence Programs. I'm taking all but one of these statistics. Anti-LGBTQ homicides in 2017 increased by 86%. That is excluding the Pulse nightclub shooting in 2016, which killed 50 people, obviously, a terrible tragedy. I believe it was excluded because that's a one-time, hopefully a one-time event, something that doesn't happen very often. So that was excluded from the data. What else do I have here? So in 2017, 45% of the homicides of queer, bi, or gay cisgender men were related to hookup violence. Most of these were related to hooking up online or through personal ads. There appears to be a trend of targeting queer, bi, or gay cisgender men for violence, robbery, and homicides, and other cisgender men are using these sites to identify and harm them. As technology improves, the ability to specifically target your victims also improves. And a stat that I believe proves that this stat says 32% of LGBTQ people who were murdered were for being LGBTQ knew their murderer. That stat from the Bureau of Justice Statistics, 70 to 80% of people, the total population, are killed by somebody that they know. So 30% compared to 70 to 80%. That is a massive difference, and that's because people who don't know queer people are saying, I'm going to kill you because of who you are. And that is happening. There's also gun violence in terms of killing LGBTQ people is lower than it is compared to the general. It's 53% to 67% of murders by gun death, which means that they're stabbing and beating LGBTQ people to death instead of shooting them. And then I have mostly just a list, just this disclaimer at the end of these stats, because I think it's fair. The information's not exhausted. NCAVP knows the number of homicides is likely higher, as some homicides of LGBTQ people are not documented because of misidentification of victims' sexual orientation or gender identity in media and other reports. Additionally, motives related to anti-LGBTQ bias can be difficult to discern, as media and law enforcement are often reluctant to say that a homicide is related to violence. I don't know now if we're going to the next speaker or to probably Representative Price's grilling.
All right, have you finished your testimony? Representative Price, have you finished your...
I
you
have,
finished your
yes.
Okay. Any questions for Mitchell? Representative Price.
So what you're saying is that it sounds like people are getting misidentified and they're victims of crime. When there's a crime that happens, should all the factors be incorporated into a jury's decision without eliminating some of the really the factors that may have contributed to the alleged crime? I mean, is not identifying yourself.
So I've heard two questions so far, if I can answer them. The first, just to clarify, these are not statistics from court cases. These statistics mostly come from police officer statements, the media, things like that. For example, if Representative Filippi is sitting right next to you, I believe that's how you pronounce your name, if he ends up dead, I have no idea if he's gay or not. I have no clue. Somebody might identify that information, somebody might not. So it could be difficult. I thought you were identifying
this as the gay LGBT community getting killed because of people not knowing their identity. Isn't that what you stated?
No, it's not. It's not getting killed because of not knowing their identity. It's because of knowing their identity and hating them for it.
And I think what he said, I certainly don't mean to put.
No, I
words
don't
in-
think that's the case. I think the case
Representative
is,
Price, I think what he said is the statistics may have some level of underreporting because it's not always known what what sexual identity the victim
he also
was.
said that his statistics were somewhat faulty, and
Undercounted,
underaccounted or whatever.
but in any situation, we undercount all sorts of information.
So you're saying
Police
it's a
shootings,
hate
for
crime
example.
when someone finds out that you've been deceived, and that, I mean, what if someone lies to you and steals your money, and you've been deceived that way? Should that be not included in a court trial?
If
What if
somebody-
Hang on.
what if somebody?
Representative Price, that question had no relevancy to the bill before us, so Mitchell, feel free not to answer that question. Do you have another question, Mr. Price, Representative Price?
Do you think that no.
Okay. Mitchell, if you could give, before you leave, your the paperwork that you were quoting from to the clerk, she'll make it part of the record if you want to.
Okay.
Randall, you want to go to Sampson? Sampson. Thank you for waiting patiently this evening.
Good evening. My name is Samson Hampton. I apologize if I stumble over my words. I am.
That's quite all right.
I'm highly offended and quite honestly almost speechless at Representative Price's outrageous remarks. I identify as transgender. And I am a volunteer with an organization called the TGI Network. And I have been asked by the leadership of the TGI Network to convey a message that they agree with your decision to hold the bill for further study. They would like the Civil Law Association, the Criminal Law Association, to study the bill, and if they find that it's necessary, I would like to present my personal testimony from this point forward. I just wanted to deliver that message from the TGI Network. I apologize, my testimony is on my phone. I had very little notice about this bill being heard.
That's okay.
I found out about it last night, very late last night. So I'm from Providence. I am in Senator Golden and Representative Rugenberg's district. And as I said, I'm a volunteer of the TGI Network, and they are an organization which supports the Rhode Island's transgender and gender nonconforming community. And I'm also an advocate with the Center for Popular Democracy, which advocates for LGBT rights and other progressive issues at the national level. And I'm here today in support of H7066 with further study and the support of the Law Association. And I am hoping and praying that we never have to use this bill in this state, but the reality of LGBT violence is real, and Rhode Island is not exempt from it, no matter how liberal we are. About a year and a half ago, a young trans woman was stabbed on the south side of Providence, less than 2 miles from here, over on Elmwood Avenue. Fortunately, she survived. However, if she had not, her accuser may have very well tried to use this tactic, this defense of trans panic. Transgender people should not be subjected to violence and often death because of their very existence. And I'm going to repeat that. Transgender people should not be subjected to violence and often death because of their very existence, which is what is happening in these crimes. They are being killed for who they are. Approximately one trans person is murdered every week. Now, that statistic is not coming from a third world country that's highly conservative. That statistic is coming from the United States of America. One trans person killed every week. Approximately 52 trans people are killed in the United States every year. Every year, the trans community has a day to honor the dead. It's called the Transgender Day of Remembrance. And every year we say that we need to do more to stop the killings. Well, this is a start. Let's close this loophole and then continue to work to support the underserved, over-marginalized trans community here in Rhode Island. We are here. I am here. We are here and we are asking you to do the right thing. As my friend Remy says, do better, be better. That is exactly what we have to do. And I would like to say, in regards to the remarks Representative Price has made, there has been some misinformation thrown about this room. Transgender people do not deceive people. I have the right to disclose my gender identity status when I feel as I should. That is my decision, nobody else's. And when I disclose that information, that does not give a person the right to kill me. And that is what this bill is about.
Thank you, Sampson. Representative Price, are you sure you want to ask a question?
Yes.
Okay.
Defense on the LGBT community, and I'm not against it in any way, but, I represent the heterosexual community, and this bill would essentially eliminate any defense that my sexual preference has, and
It does not give you the right to kill me.
I'm not saying that it does. I don't think anybody has a right to kill anybody, and I'm not saying that. I'm just saying that all the facts need to be put in front of the jury in order for them to make a sound decision onto what happened.
My answer is it does not give you the right to kill me.
It's not what I'm saying.
Okay, any other questions for Sampson? Thank you. Randall?
Thanks, Mr. Chair and members of the committee. I think I want to be a little more clear about what's going on in these cases. If you look at all three clauses of the bill, the part about the defense of provocation, the diminished capacity, and self-defense, all of these are cases in which the idea of allowing this defense in court is based on the defendant's negative feelings towards LGBT people. And it's, if these defenses are allowed in court, we're allowing negative feelings, or what comes out of negative feelings towards a group of people, to be a mitigating or excusing factor in a crime. There's been some talk about letting the facts come out in the courtroom. Okay, so it's a fact that some people have negative feelings towards LGBT people. It's a fact there are some people who are very biased, who are willing to use violence for very bad reasons. But the question is that fact something that the law should treat as an excuse or a mitigating factor? That's what this bill does, and it is the job of the legislature to say what kinds of facts can be an excuse or a mitigating factor. With drunk driving, for instance, drunk driving was not originally a crime. A judge might have decided when the first drunk driving case came along that maybe it was a mitigating factor that this person was drunk when they caused an accident. But the legislature says drunk driving is not a mitigating factor, it's an aggravating factor. So it's, and that's definitely something that's important, an important decision for the legislature to make. Unfortunately, LGBT people right now are in the situation where when people are violent towards them simply because of what they are, that's treated both as a mitigating factor and an aggravating factor. So the law is inconsistent. Sometimes the law, as Representative Knight says, sometimes the law in Rhode Island does allow prosecutions that are predicated on somebody's animus against LGBT people, but sometimes the law allows that, if the judge is so minded, to serve as a mitigating factor. That's just inconsistent. There's no reason why the law should treat it in these two opposite ways. And it's And I think even if there wasn't any inconsistency, it's still really deadly if the state of our law sends a message that it's okay or relatively okay to use violence against one group of people. Because that's saying this group of people does not have the right to equality. That's not what the law is here for. It should be a matter of freedom. It should be that everybody, no matter who they are, what kind of person they are, should have the right to live freely. Who they are should never be considered a mitigating factor for violence against them, because that right there, if there's even the slightest hint of that in the law, that makes you, in the eyes of the law, a second-class citizen, and we should not tolerate that. And even if that kind of case has not happened in the courts yet in Rhode Island, we don't want to get into a situation where that case does come into the court and it gets all over the media that somebody was let off easy because their victims were somebody that the law allows this defense against. That kind of thing is going to, if that happened in court, it would send a really terrible message to the public. It would lead to more violence. It would lead to more discrimination. We can't allow things to get that far. We have to head it off before there is a court like that, because if you have a court that says if you have a court case that's publicized that says this is not acceptable as a defense, that sends the right message. It helps allow a lot of people to live in more freedom. And helps them be for equal citizens instead of second-class citizens. And I do recognize these negative feelings exist. I wish they didn't exist, but they do exist. These stereotypes and biases and bigotry does exist in our society. But, this actually is not the first moment in history where this kind of thing has happened. In the past, there have been societies which were divided between two religious sects that had intensely negative feelings against each other, and one religious sect might think it was fine to use violence against the other sect. And if you have that kind of thing, if the law accepts that kind of thing as an excuse, then those two groups are just not going to be able to live together. One of the reasons why that went into our founding constitutional law was to allow people of different religions to live together and to send the message that you do not allow this kind of violence against some kind of group. Even if there are these intense negative feelings, the law should not accept that as an excuse. In fact, it should be the law's job to try to reduce those negative feelings in society. Unfortunately, LGBT people have been the victims of these negative feelings for a very long time. They didn't get this protection as early as we got the protection for religious differences, but they do need this protection. At least when I was in middle school and high school, there was traditional to use LGBT people as scapegoats. People were accused of being LGBT if they're not. I shouldn't even say accused. They were. That was used to target people for violence or for other aggressive actions. And if we tolerate that kind of this kind of idea in society that says that somebody's who's LGBT, their identity makes it more legitimate to use violence against it, that puts everyone in danger, but it would be bad even if it just put a few people in danger. This really should not be accepted at all, and if we put this on the books, it's going to have a good effect in a lot of ways. It's going to actually encourage prosecutors and police to use their prosecutorial discretion better, because right now I think one reason why some of these cases don't go to trial is because prosecutors don't want to bring them into trial. Putting this on the books will send a message that LGBT rights are important, that they are human rights, and that LGBT people deserve to be protected from these poisonous negative feelings that are widespread in society. And I'm not entirely blaming people for having those negative feelings because they didn't originate them, but I do think we have to get rid of them, and we can't allow that to be an excuse because, if you start bending over backwards to be sympathetic to the person who is violent, and you allow this message to continue to be sent that some people are second-class citizens and violence can be used against it, that has a much more devastating effect, and you have to wonder why we're bending over backwards to be sympathetic to the violent person who used violence for no good reason, instead of the person who is actually being harmed. So I think that on balance, this is a very good bill, and I think we can recognize that these negative feelings exist, but we can send the message to anybody who's thinking of using violence. You can never let those negative feelings push you into violence. You have to control them, and maybe you have to make yourself a better person and not be so biased. So that's what I would have to say about this. Thank you.
Thank you, Randall. Any questions? Okay, we do have from Representative Marshall, the sponsor, a report to the House of Delegates from the American Bar Association Criminal Justice Section, and a compendium of cases and fact patterns that have happened in the past. And with that, we will conclude testimony on House Bill 7066 by Representative Marshall.